Mr. Brown, you were ready on. We think Mr. Johnson is also present for you soon.
This case starts quietly, but don't let that fool you. What you're about to see escalates fast. We're stepping into a courtroom where emotions are already running high and the tension is thick before the first serious word is even spoken. This is not a routine appearance. You've got a defendant who clearly feels overwhelmed, a court trying to establish order, and a charge that carries massive consequences. Witness intimidation is one of those allegations judges take extremely seriously because it strikes at the heart of the justice system itself. If witnesses feel unsafe, cases fall apart, and courts do not tolerate that. As we move forward, pay close attention to how the judge frames his questions. He's not debating guilt here, he's ensuring understanding. That distinction matters more than most people realize. And here's the question I want you thinking about from the very beginning. When emotions collide with courtroom rules, should intent matter more than impact, or does the system have to draw a hard line no matter what's going on emotionally? Keep that in mind, because it's going to come back in a big way.
Court does call the case of the people versus Lawrence Buckner.
Joseph McMillan, people, Your Honor.
All right. Mr. Johnson, you're muted, sir. Go ahead.
May it please the court, Kareem Johnson, defendant on behalf of Mr. Buckner.
All right.
What about that mention of anticipating the plaintiff? Are we doing arraignment?
Yes, I'm going to do the arraignment. And just to bring you up to date, Mr. Johnson, the new case that we were talking about has actually been, I now have the file and I'm going to conduct the arraignment on that charge. So, all right. I don't know if you were informed of that. All right. Your name, sir?
Sir, my name is Lawrence Edward Buckner Jr.
All right. You are before the court on a felony complaint, a one-count felony complaint that alleges that on or about April 1st, 2025, at the location of 4133 Washington Avenue, that being the 14A District Court, that you did influence or attempt to influence the testimony at an official proceeding by threatening to kill or injure a person. It's commonly known as witness intimidation, committing a crime threatening to kill or injure. Not asking you, sir, whether or not you believe you did that offense. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony. It is punishable by up to 15 years incarceration and or a $25,000 fine plus court costs. Do you understand that? You understand that, sir?
Yes, sir.
And you understand also, sir, that a consecutive sentence may be imposed for any other conviction. Do you understand that? Mr. Buckner, you can sit down while we go through this.
All right, sir. I didn't know. I'm sorry.
Did you understand that, sir? That a consecutive sentence may be imposed for any other conviction.
Sir, forgive me for my emotional upbringing. I don't know what to say right now, sir, and I truly apologize to the court. I don't know what to say yet.
This is where the human element hits hard. The defendant is visibly struggling, emotionally overwhelmed, apologetic, and clearly not processing information smoothly. From a legal standpoint, the judge handles this carefully but firmly. He's not dismissing the emotion, but he's also not letting it derail the process. Courts require competency, not composure. You don't have to sound confident, you have to understand. And that's why the judge keeps circling back to the same two questions. Do you understand the charge, and do you understand the penalties? This repetition may feel cold to some viewers, but it's actually protective. If this case goes further, nobody can later claim the defendant was kept in the dark. Here's the engagement question for you. Should courts slow down when someone is clearly overwhelmed, or does consistency matter more than compassion in moments like this?
Well, I just need to make sure that you understand and can answer the questions that I'm asking. I need to make sure of two things primarily. First of all, that you understand what you charged with. You told me that you do understand that. The other thing that I need for you to understand is what the maximum penalties are.
So there's no video.
You may want to mute that.
So this is my, this is my freedom is just snatched from me, and I was understanding this son who I came to y'all can talk to me. See, I told you I got shot in the head, so you got hearing the wrong thing. Okay, and you said about video, but now you tell me no video. That's what I'm not understanding, because the whole basis of my freedom today was Judge Simpson viewing the video, and that's why I need help. Oh, this, what charge is this? This is the charge of having April 4th in Judge Washington Court? Okay. Potentially. I understand the potential. I just, from the time, and I apologize ever since, and I'm a little slow right now, so I apologize to the court at any time. Y'all be further ahead of me. Second to original charge. Second to original charge, Ms. Johnson, Ms. Washington, one bond. Yeah. I understand, Judge. I'm sorry, I don't.
Okay, so you understand then the maximum penalties on that charge?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney on this? It's a public defender case.
This is a critical procedural checkpoint. The right to counsel is fundamental, especially in felony cases. Once a defendant confirms they want representation, the tone of the case subtly shifts. From this point forward, most communication should go through counsel, not emotional outbursts, not direct appeals to the judge. Notice how quickly the court moves once representation is confirmed. Plea entered, probable cause hearing demanded, and the machinery of the case starts turning. This is efficiency, not indifference. The system is built to move cases forward, even when defendants are panicked. But here's something many people miss. Demanding a probable cause hearing is a strategic move. It forces the prosecution to show there's enough evidence to move forward. Do you think this is a smart early defense move or just a standard response in a high-stakes case like this?
As to the formal reading, you waive any further formal reading of the complaint, standing in. All right. All right. Defendant pleading not guilty, demanding a probable cause hearing. Court will enter that plea. Set a probable cause hearing, and Mr. Johnson, before I set that date, were you asking for an adjournment of the other case? You were asking for that to be set for exam, were you not?
I was, Your Honor, but based on these new developments, I think.
Stay in jail. I'm not trying to stay in jail, Mr. Johnson. Like, please help me. I'm not trying to stay in jail.
I will.
Like, I want you to tell the judge to adjourn something. And then I need to be heard on it. And I could find out I did nothing wrong. I need help. And helping me is not leaving me inside Washington County Jail or trying to put me on some type of crazy bond. Like,
Your Honor,
I don't know.
okay, Mr. Buckner, Your Honor, based on my client's representations, I still
This is defense lawyering in real time. The attorney is signaling that witnesses exist and that time is needed to subpoena them. That matters. Preliminary examinations can shape the entire case. Sometimes charges get reduced or dismissed here. But listen to the defendant in the background. Fear of staying in jail, fear of being misunderstood, fear of being silenced. This is where defendants often hurt themselves by speaking emotionally instead of strategically. Judges hear fear every day. What they respond to is structure and evidence. The defense requesting more time is not delay for delay's sake, it's preparation, and preparation can mean freedom. Let me ask you this. If you were facing years in prison, would you trust the process to work itself out? Or would you feel the same panic we're seeing here?
as I indicated this morning on my case, Mr. Buckner has, I believe, 2 or 3 witnesses that we would like to try and call at exam. I need some time to subpoena those witnesses. So I was asking the court for an extra week.
So if we were setting the 15th, you would be looking at, say, the 22nd, you're saying?
Yes, sir, Your Honor.
All right. Any objection to that from the people on case ending in 1120?
No, you're saying that for 20 seconds, not.
All right. So in that matter, preliminary examination will be in person. It would be set for April 22nd, 2025, 9 a.m. That is before Judge. Well, all right. Right, but I think that will be before Judge Washington. All right, and on that case, his bond would continue. All right. So on the other matter, I'll set preliminary examination and I hear what the defendant is saying. What date? PCC. I set it for the 17th. Card. Okay, then I'll set it for the 10th. I'll just set it out a week. April 10th, 2025, 9 a.m. on that matter. As to bond in this case.
The allegation here is that my client allegedly had some outbursts and witness and didn't explain examination. I had a chance to look at what was available on the equipment that was done. Looking at weakness. And the strongest the argument. Charge with destruction is witness intimidation. That means that he was trying to prevent this witness from coming to court, testifying, trying to change what this witness had said. All of it goes to whether that witness would be able to appear in future court. Taking the best heard in the prosecution. Said you've been lying on me. The setbacks, my client is not saying he said that. But what the prosecution says that you've been lying. She killed you or something to that effect. She shoots you or kills you. Yeah. Notion is for threatening intimidation is that he has to be doing something to prevent this witness saying, don't come to court, trying to stop this witness. I think even if we hold her examination based on her, I don't think the prosecution should be able to take out a case that his intent was to try to prevent this witness from showing up, coming to court, intimidating this witness from saying, testifying truthfully. That's necessary. Because I do not believe that he will be successfully given conviction, I'm asking that the court set for my client a personal cognizance bond. And here's the reasons why a personal cognizance bond. You have the ability to have no contact. It has a home, Ypsilanti, 680 box. It's not having anything to do with it. Money witness lives separate. He's self-employed, he raises dogs to sustain himself. He suffers from numerous bad living networks already raised that he's been shot a lot of times. So he's got health problems that arise from that. Finally, he lives with his autistic needs, he has to take care of. He also has a brother who can help make sure that he returns to all future workmates. It's a responsible individual. They should. I think the charge here is a strong charge. I think it's a charge that even taken in the light most favorable to the prosecution, they will be able to prove that he probably caused that.
Thank you. Response.
Thank you, Your Honor. In this case, as in many things, context is key. This exam was first this Tuesday. At that time, the victim testified and examined. The defendant pointed a gun and racked it at her while she was working as a security guard. It was after this that the defendant asked her to go to the bathroom. While walking out, threatened her in the gallery. She immediately reported this to the victim advocate and the assistant prosecuting attorney.
This is the moment the case turns sharply against the defendant. The prosecution paints a vivid picture. Testimony given, a firearm allegation already in play, and then an alleged threat immediately afterward, inside the courthouse. That context is devastating. Courts are sacred spaces in the legal world. Threatening a witness there, if proven, is viewed as brazen and dangerous. Add in a prior no-contact condition and an existing criminal history, and you can feel the weight stacking up fast. This is why the prosecutor pushes for a high bond. Bond isn't punishment, it's about risk. Risk to the victim, risk to the public, risk to the process. And here's the key engagement question. If someone believes a witness is lying, where is the line between anger and intimidation?
Specifically, this defendant said, "You're lying, a lying fucking bitch, I'm going to get you." This is right after she testified being threatened with a firearm by this defendant. Based upon this defendant's conduct, Your Honor, people believe that a $100,000 bond, no 10%, is appropriate in this case. This was very clearly an attempt by this defendant to intimidate this witness with regards to the case at District Court exam. The condition of the bond in that case, case number 5-121, I'm sorry, I may have misread that case number, was that he had no contact with the victim, and here he is in court threatening this victim. This is not taking place in a vacuum. This defendant has a pending misdemeanor domestic violence case, the FA case that was the subject of the exam involving firearm, and malicious destruction of property felony case. Based upon this conduct, based upon his extensive criminal history, they frankly have extreme concerns for public safety and victim safety. We're asking that as a condition of the bond in this case, that he have no contact with the victim in Hudson, have a no-go order as for a residential place of employment. And frankly, Your Honor, it is this defendant's conduct which has brought us to this point. And the fact that this threat was uttered during a court proceeding immediately after the testimony of the victim is greatly concerning to people. And to our mind, points to a need to set a significant bond to secure the safety of the public and the state.
So I can respond, Your Honor.
Yes, sir.
Obviously, very clearly, something different in the prosecution that describes it as an angry outburst. It doesn't rise to showing any intent to keep anyone doing anything except that angry outburst. They would make hay and try to charge a witness intimidation. It's not that the person already testified, said she was lying, was angry, it was an angry outburst. But we're not going to try to hear it, show the prosecution instead. Things that the court takes into consideration is the likelihood of conviction. I think the likelihood of conviction is, as the prosecution says very clearly, I think that's the case at all. And what you have is not angry outburst that's being spun, something based on what they saw in context, an unproven charge.
But if it were directed at the victim in that case, that irrespective of what's being said, that would be improper conduct, you'd agree.
That's right. Making a bond with a separate case, and that's exactly what's going on.
This is Judge Simpson doing something important, separating emotion from conduct. Anger alone isn't a crime, but direction, context, and impact matter. The judge acknowledges what defense is arguing, yet draws a hard boundary. If those words were directed at the witness, especially under court restrictions, that changes everything. This isn't about free speech. It's about safety and integrity. Judges don't need proof beyond a reasonable doubt at this stage. They need credible concern. And from the judge's perspective, the setting, timing, and consistency with the underlying charge all raise red flags. Think about this carefully. Should courts give defendants the benefit of emotional doubt, or is it safer to act decisively when patterns emerge?
They can certainly say you shouldn't have said anything. You shouldn't have an angry outburst. That's a bond violation. That's exactly that. In the context of whether or not they should be charging this case, and with this their discretion, if they decide context of whether or not they're likely to get a conviction based on that flimsy information they have there, that's not right. So yes, maybe they can say it's a bond violation. They should be actually bringing a bond violation rather than charging an entire case. They can't complain to me and say, oh, well, we've got a new case based on that.
So there seems to be a misperception because the victim testified at exam that somehow this conduct was not committed to the victim. The victim's testimony would be needed at trial as well. And to make this statement, not only that he accused her of lying, but that he was going to get her, when this same victim has seen this defendant fire off at her and rack the weapons. Clearly, the intent here was to intimidate the witness in question. So based upon this defendant's conduct, I need a $100,000 bond with no 10% is an appropriate remedy. As an additional condition, Your Honor, should this defendant be able to go, yes, or GPS tether, it will go conditions as to placement of employment and residence to the victim. But very clearly, this defendant conduct was demonstrated with
I don't know that I have a name for the,
the name of the victim, Your Honor, is Amy Hudson. That's A-N-E. The first name, Hudson.
say again?
A-M-E-E.
Okay.
Last name Hudson, H-U-D-S-O-N.
Anything else?
No, the way it works is it's on a motion, they respond, and it's supposed to stop.
Well, I can actually run my courtroom any way I want, but that's okay. Thank you for the suggestion. I'm going to order standard conditions, including no assaultive behavior or any possession of any weapons or anything fashioned to be a weapon. There's to be no possession of any alcohol, recreational marijuana, or any illegal drug. I will order no contact with Amy Hudson. You're not to go to either direct or indirect.
This is where the court shifts from discussion to enforcement. Judge Simpson is now laying down concrete bond conditions, and these are not light restrictions. No contact means exactly that. Direct, indirect, or through third parties. No social media mentions. No showing up at a residence or workplace. These conditions exist because courts understand how intimidation can happen without a single word being spoken face to face. A post, a message passed through someone else, even a vague reference online, those all count. The judge is also stacking standard safety conditions. No weapons, no alcohol, no drugs. This tells you the court is not just thinking about this one moment, but about controlling risk moving forward. Here's a key engagement question. Do restrictions like social media bans go too far, or are they necessary in cases involving alleged threats?
Or through third parties. I will also indicate that there's be no mention of Amy Hudson on any social media or any use of any type of social media. You're also not to go to that person's residence or employment, or place of employment, I should say. What is concerning in this case is that if what is said, and I disagree with the defense, that there has to be something where they did that there. If said, if what is indicated was said, which oddly is consistent with, in some respects, with the underlying offense and what is said, which makes it even, I will have to say, more frightening if it was said. And that it is said during, even at a recess, but during a court proceeding where the defendant knows he is not to have any contact with that particular individual, is highly problematic and something this court cannot tolerate. Should it be that type of individual?
Listen carefully to the judge's language here. This is not emotional, it's institutional. When Judge Simpson says the court cannot tolerate this behavior, he's speaking on behalf of the justice system itself. Threats during a court proceeding strike at the core of fairness. Witnesses must be able to testify without fear. The judge also makes an important distinction. He doesn't necessarily see the defendant as a flight risk, but he does see a danger risk, specifically to one individual. That distinction matters because it directly influences bond decisions. Courts are not just balancing freedom versus detention, they're balancing safety versus risk. And when a judge explicitly states someone poses a danger, bond conditions tighten fast. Ask yourself this: if a judge believes someone is dangerous to even one person, should that outweigh every other factor?
In this court's mind, does pose a significant threat to the public in regard to his behavior. I would also indicate that I don't necessarily believe that the defendant is a flight risk, certainly, but I do believe that given everything that the court has heard, he is a significant danger, if not to the public in general, to this one individual. He may be a particular danger. The court is going to set the defendant's monetary amount of his bond at $75,000 cash assured. If the defendant is released, he is to be placed on the GPS home confinement tether. The court may allow, upon petition, his ability to go to work once that's established, but $75,000 on that case. Thank you.
This possibly from the judge Washington. It's probably the same stuff that they charge me for right now. Same stuff that they charge me for right now. A prosecutor told Judge Washington that I was disrespecting and threatening her client inside the jail, inside the courtroom. Judge Washington looked right at her and said, "No, you're not." He looked right at me. So I asked you to talk. Judge Washington couldn't help me on this. Because they got me charged on. They got me charged, Judge. And so this thing, right, for me to make one statement, Judge Simpson, I'm charged with making a crime in the courtroom, right, sir?
Now we see the defendant pushing back, confused, frustrated, and convinced that video evidence will clear his name. This is a common moment in courtrooms. Defendants believing there's a single piece of evidence that will resolve everything instantly. The judge's response is measured and procedural. He doesn't argue facts. He doesn't evaluate the video on the spot. He redirects the defendant to counsel because that's how evidence is properly introduced. Courts do not litigate cases during bond hearings. That distinction is critical. From the defendant's perspective, this feels like being unheard. From the court's perspective, it's maintaining order. Here's the question for viewers. If you believed video proved your innocence, would you trust the system to review it later, or would you feel just as desperate to be heard immediately?
Well, you're charged with intimidating a witness that may have taken place in the courtroom. So.
Okay, and sir, this is the time that I got arrested and you sent me back here. The thing that I was trying to work on you was, the community of people that was helping me, sir. And I know everything I'm saying, that you already made a decision, is that the video inside Judge Washington's courtroom, a Wayne Washington courtroom, was the video that would have proved my innocence. The prosecutor told Judge Washington that I was threatening Amy Hudson while she was giving her testimony on the stand. Amy Hudson was on the stand. Wayne Washington stopped the court immediately and said, "No, he's not. He ain't looked at her. He ain't said to her. He's mumbling things to me, trying to get my attention." This is on camera in Wayne Washington court. So now, how do I help myself, Judge Simpson?
Your attorney will be able to get a video of that proceeding. All right, Mr. Buckner, thank you.
This short exchange carries a lot of meaning. The judge is effectively saying, there is a process, use it. Judges rely on attorneys to filter emotion into admissible argument. If the video exists and supports the defense, it will surface at the right stage. But until then, the court moves forward based on what's formally alleged. This moment highlights the biggest disconnect between public perception and legal reality. Courts are not truth-finding theaters in real time. They are procedural systems. That can feel cold, but it's designed to protect everyone involved. Think about this. Does the legal system do a poor job explaining this process to defendants, or is it simply impossible to bridge that emotional gap?
Hey, Mr. Brown, Mr. Brown. Yes. Thank you.
No, I don't, but I conditions. Okay. All right. Thank you, Mr. Brown, and I appreciate that lesson on how to conduct a court. No, I always appreciate the help. No, well, some places do it that way. I just let people talk. Okay, you know that because you're still doing it. Okay. Have a good evening. Is the personnel?
Yes, that's Mr. Bruce.
Oh, is he into? All right, court does call the case.
This case leaves us with a powerful snapshot of how quickly courtroom dynamics can shift. A defendant facing a serious underlying case, an alleged threat made in a courthouse setting, and a judge tasked with protecting both individual rights and public safety. Judge Simpson's ruling makes it clear. When alleged intimidation occurs during a court proceeding, especially involving a prior no-contact order and firearm-related accusations, the court will respond firmly. A $75,000 bond, GPS tether, and strict no-contact conditions reflect the gravity of that concern. Whether the video evidence ultimately supports the defense remains to be seen. But at this stage, the court acted on risk, not resolution. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.